So it came in the afternoon. No, the ministers came in the afternoon. The reply I only saw this morning. That's why my brother didn't see the reply. And then I realized this morning when I got to the office, the heads of argument were also uploaded. And they were also uploaded this morning. He wanted to deal with that the minister was late with the day or two. Because we can engage on the urgency. But it doesn't make sense in a matter like this just to show you the door on urgency if we can deal with the other issues. Not that Mr. Premier will not be allowed to argue. So it's not only you telling me that you didn't comply with your self-imposed timelines. It's about treating the court with respect as well. Thank you, Mr. Kasiput.
As the court pleases. My Lord, I have no intention or insistence on going on urgency if the court is not inviting me to deal with urgency. All I sought to do was to say the time frames were changed as per the notice of motion, and I don't want to get into the details of that. I was just simply trying to deal with that issue, and my apologies if the court took umbrage with that. It was done in good faith. In response to Justice Snook, so the first point I've made is that if you have regard to the replying affidavit as 010-13, you will see a heading there numbered Roman numeral 7 VII. It's
prospects of success are overwhelming.
At Part B.
Mm-hmm.
So
it's paragraph 31, which is 12 of 26 in the affidavit, and it's 010-13 on case line reference. I'm just reading it out aloud, Mr. Kasibota, because my colleagues doesn't necessarily have the case lines open, but the hard copies.
And if I could just give you the heads reference, if my Lordship is minded to read or have consideration of both. Under pages 054-48 of case lines, these are heads of argument. The heading there is Prospects of Success in Part B. So that's where we deal with the prospects of Part B. From paragraph 73 of the heads of argument. And perhaps I'll pause for a second for the court to orientate itself and to direct me to address it further.
Heads of argument, paragraph
73 at case line 054-48.
But on the replying affidavit, it's paragraph 51, right?
Indeed, Your Lordship.
But that does not really explain to me what the problem is with that mechanism that Section 48 provides for. Because at 31.1, the reference is made to the budget speech. I think the minister says that the budget speech is not the one that does the imposition of the levy. It is the amendment of the schedule that is in existence. So we have a schedule that is there to the customs, that he is merely amending. So I think if there is any offense, that must be the offending part, not merely the speech, or am I missing something?
Justice Nuku, let me answer the question, and I had a whole list of the ones you asked me. I'm hoping we'll get to answering all of them, so I'm not avoiding them at all. And the sweating is not of desperation, I'm diabetic. So,
I can't see from the distance, so you are fine.
An amendment is not a mere amendment with respect, Justice Snuku. What it achieves is what matters. So to use the word amendment instead of passing a money bill to increase levy are not necessarily two different things. If the net effect of that amendment is to do the same thing, we are contending that is exactly what the minister has done. So it's not a mere amendment. Its consequence is the consequence foreshadowed by Section 77 of the Constitution, which says if you impose a tax or a levy, which the minister says I have done, then you must do that in terms of a money bill. So if he achieves that...
So is that to say that for the other years, this thing has been done incorrectly? Is that the gist of it?
That's the sum total, and there's nothing wrong with the constitutional challenge for the first time. There are many laws in this country that were unconstitutional. They find their way to the court, declared unconstitutional, they are corrected, and we move on. We can't, on the basis of it's always happened that way.
I'm just trying to understand that now the applicant says that, no. That's not the way to do it. You may have done it and gotten away with it, but it's not the argument.
Indeed. And this is quite strange to suggest that the EFF can just cloak a provision.
But this part, I mean, there's very few, there's not much which is being said on the prospect of success. It demonstrates why it is that mechanism falls short, because the minister explains there that there is this mechanism, a gazette, it is subject to parliamentary oversight, there is a continuation provision, it may be amended. I have no final word in this document. The final word is with the Parliament.
And I accept that.
And so if the court intervenes at this stage, it will be mid that process. And I don't see the engagement with all of that to demonstrate that there might be a problem, which then will be dealt with in Part B, in respect of which the applicant says it enjoys prospects of success.
As the court pleases, Justice Snow. The first point I wanted to make is an argument, and I don't want to leave it undealt with in case it carries any weight. The EFF's so-called acquiescence with that process 7 times before cannot now cloak an unconstitutional conduct as constitutional by acquiescence. It just simply cannot be. In dealing with the question of the prospects of success, we understand a founding and an answering and a replying affidavit to an exposition of the factual disputes and the full context factually. There seems to be no disputes as to the facts. What our prospects of success are in Part B is a legal question, and therefore it requires legal argument. We do far more in the heads of argument dealing with that legal question. We took a position that for an urgent court, what we do not want is to argue in a founding affidavit, argue in heads of argument. If Justice Snuku's concern persists even after I've taken you through the heads of argument, then I'm happy to deal with that contention at that point. But the upshot is this. Yes, and the case reference that I've given earlier is from paragraph 73 of the heads of argument. So we deal again with that question, but in legal argument rather than fact.
Because you say it's a legal argument.
That's the point, Justice Snuku. And I also want to deal with some of the questions that arose, then I'll be directed where else the court would like me to go, but I think these are very important. There seems to be an acceptance that what will happen is that this decision by the minister will serve before Parliament.
So it's paragraph 73 until?
It goes on and on up until 83, and there are other references specifically dealing, and I'll take you to them, but 73 should suffice for now, just to know. And the point we simply seem to make is, it is not a foregone that this will serve, this decision shelved before Parliament, because the respondent says, in terms of 48.6, this decision will be before Parliament, therefore the parliamentary oversight that we insist on. But 48.6 does not mandate or compel the minister to present what we call is in effect a money bill. Because, why do we call it a money bill? Because in terms of 77, anything that you do to increase levy or taxes must be done in terms of a money bill. So what Justice Nuku calls a mere amendment is in essence that what we cannot dispute is that the price of petrol today is this, it will be higher come tomorrow. In essence, it's imposed tax and a levy. Let's accept that as a starting premise. Our constitutional contention, which is now this part B, is that he cannot do that outside of the scope of presenting a money bill. Because Section 73 of the Constitution says he must do that. The second issue we also raised in the heads of argument is this. In terms of the Money Bills Act, once the minister tables his budget, it must serve before Parliament. Parliament must take it to the Standing Committee on Finance, at which point they will consider the fiscal framework which proposes these increases. That is exactly what is happening now in Parliament. And once the committee takes a decision that we are not happy with this increase, which is a legislative oversight, then they must propose amendments to the minister. Then the minister then decides whether he accepts that proposal or not, but ultimately be voted on by Parliament. Now, our point is this: the minister, with respect, has preempted and bypassed that process and basically nullified the current process happening in Parliament, which specifically has to deal with this specific issue. Last Friday, that committee sat and it took public representations, particularly on this issue of the fuel increase. Submissions were made. The committee is considering those submissions, and then they are mandated to give a report to Parliament. And if they propose changes to the fuel levy, they must give the minister 2 days to deal with that contention. And the idea is the parliamentary oversight will then ensure that he's not taxing without representation. He has bypassed that process. And is not saying there's an urgent need for it now or any other issue dealing with regulation, but to just make good the fact that he did not come right with that. That's what he says. So strictly speaking, as a matter of concept, there's nothing about the fuel itself specifically that requires this adjustment. Is to make good what he didn't get right, illegally so, with the VAT issue. That's the point we're making. And I was saying the problem then becomes twofold, and that's what we say in our heads of argument. One, there is a mandatory Money Bills Act, which is underway considering this very issue. It is happening now. That's the process. It makes negatory of that process if the minister is doing what he's done now. That's the same problem we faced in the VAT matter. So if the minister is genuine about this parliamentary oversight that he keeps making reference to, then why doesn't he respect that process? If he's saying, well, this process will come of oversight later on, well, it will come only in October, he tells us, whereas the issue of the consideration of the levy by Parliament is happening now. So which will come first? So if he's authentic about wanting to be held accountable by Parliament, then let that process run, and then Parliament will vote on whether they agree with the fuel increase or not. So the minister now seeks to purport that he's merely exercising his power in terms of 48. Well, with respect, he's not. He's doing it in terms of the budget. It would have been one thing if the minister had made this decision 5 days before the budget or 7 days after the budget. He can't now carve it out of that process. The point I'm making is, if he's doing it in terms of the budget, the Money Bills Act kicks in. And part of that process is for all these committees to review his decisions, vote on it, present it to Parliament, vote on it. That is what is legislatively mandated by the Money Bills Act. So if he's couched it in his speech, the money bill says, then that process kicks in. And that process has kicked in, and it says it culminates with the minister presenting a bill before Parliament. That has not happened because the minister has decided it's going to cover just this one aspect and pretend it didn't form part of the budget. The difficulty is this again, Justice Nugu. What he has then effectively done is take a unilateral decision which will continue to stand until he himself as the minister presents a bill in front of Parliament. We are saying 48.6 does not mandate him to present in front of Parliament. And if he chooses not to, then that fuel increase will take effect up until late next year. And then if he decides, given the politics of Parliament and the fact that he doesn't have sway in the numbers, then he just does the process again. That's the point. And we are saying it is not enough for the minister. You can appreciate why he'd say, well, I intend to. You can appreciate why he'd say that. He's got that difficulty, but that's not how we interpret statutes, and that's how we make determinations of constitutional validity or not. The question becomes, is he given plenary power that's unkept? Of course he is. Of course he is. And that's the difficulty. That's the constitutional challenge we say we're going to present in Part B. To the extent Section 41, and we presume E, is 48(1) sub E. We're assuming that's the provision because that's the catch-all. The minister can do what he wants when he wants, basically, is what it says, which is quite peculiar in itself. Because if you want to delegate power to increase fuel, you can't couch it in such terms. And the case law makes reference to it in heads of argument. It can't be so unfettered. It simply just can't be. And the exception to that is, of course, the Shuttleworth matters, because they were dealing with regulatory exercise of power, not tax imposition. Very, very important. Because that seems to be the basis upon which the defense by the respondent lies. They say, well, the courts have already told us we can do this. Well, if you're reading the judgment glibly, but if you're reading it properly, the court is clear, paragraphs 70 and 8 and so on, talk about we will have a problem if the minister purports to exercise this power for purposes of increasing VAT for revenue purposes. Then we'll have a problem. Those judgments themselves tell you that. They say in this instance, what distinguishes this matter from Shuttleworth and New Africa is this. I'll make an illustration using New Africa, but the idea is the same. In New Africa, consulars and diplomats were sold alcohol and cigarettes custom and tax-free. And the idea was that they use it, whatever it is that they're going to buy tax-free is for their business or their personal consumption. It was, so happens, alcohol in this instance rather than computers. And what they then did is to abuse that power by buying more than they personally need for purposes of reselling at a marked up price given the breaking customs and levy that they enjoyed. The reason the court then agreed with the applicant in that instance was because the argument was, I'm exercising this power to curb a mischief and abuse of our provisions. So what it's being used for is abuse, and the use of words abuse. They then go on and say that is distinguishable, as if foreshadowing this, that is distinguishable where the minister increases levy for purpose of revenue collection and not regulation. In other words, a plenary power to increase VAT, which is only in the confines in the province of a money bills in terms of Section 77 and 73. And if that were to happen, we wouldn't reach the same conclusion. That is what they say. That's the bedrock upon which we find foundation for application. And you do not have to agree with me now, Justice Nugu. In fact, I've perhaps spent so much time on Part B than I have on Part A. But all I need to convince you of, there is merit to my argument. And I ask you to do no further than have regard to those paragraphs and what they say about this particular conduct. And to the extent you can find the reference that says, if you are increasing VAT for revenue purposes, then you're not protected by our judgment. And if that is good enough for this court, it should then, I respectfully submit, be good enough for us to be allowed to go to Part B. Of course, we can be allowed to go to Part B with or without this court's order, but the danger is this. One, you can't reverse a fuel payment. You can't. and the degree to which the damage would have been done is neither here nor there. On the minister's own version, this is probably going to be dealt with in October. And in October, whatever happens. But what we have now is an application where pleadings are being exchanged, dealing with the challenge to the VAT Act. And we've undertaken, well, we are party to that in any event, to consolidate that one with this one to definitively answer the question. And we say with respect, there just can never be any doubt to the argument that the minister is exercising plenary power to increase VAT. Pages 7, 6, and 7.
You're saying that, you're not in that case.
No, I accept that. Sorry, just let me just explain what I mean by that. There was another matter that preceded this one.
That matter.
That matter. That matter deals with the constitutional challenge to the power of the minister in the same way we are challenging it now. So we're saying just consolidate. The point to simply make is we can expedited process rather than one that's indefinite in October as the minister would have it. And the point I was making then, Justice Nuku, is that if, and that's all you really need to look at, and without agreeing with me, but see the prospect of success. I'm going to say this for the very last time, I promise, but I think I should because it really matters to me. The sum total of our argument, and I really want the court to capture my submission on this. The entirety of our argument is that there are two types of powers, delegated powers that a minister can exercise. The one is to regulate. The courts accept that if it's regulatory power because it deals day to day with these issues, or even administrators can be delegated, that is permissible under our constitutional order. That I accept. What the courts tell us, it's not even argument formulation, I'm literally citing the Constitutional Court. What it says is that what the minister cannot do or cannot have the power to do is to, in essence, increase VAT and levy for purposes of revenue collection. And we are saying, once the minister says that's what I'm doing, and he says that is what I'm doing at page 7 of his speech, then it must stand to reason that we've got reasonable prospects of success at Part B.
You see, as my brother pointed out to you, we're not in the VAT case, and we haven't had the privilege of reading those papers. Now, Mr. Hikasibota, do you need us to adjourn? Are you okay?
No, I'm fine, Your Worship. I'm struggling with ventilation. Did you just give me a swab? We're struggling with ventilation. If we could just adjourn, Your Lordship. It shouldn't be 15 minutes unless we insist on 15. 5 should be.
It's 11 o'clock now. Maybe it's just so that we can make a plan maybe to open the doors at the back. We're currently working on the air conditioning, so that could be the issue. And that you make yourself comfortable, maybe take your medication as well. So that we try and facilitate to make it more comfortable for you.
I'm happy to. I don't need more than 5 minutes.
I have an extra fan in my office, and we're going to ask that my registrar maybe set it up for you, give you a little bit more ventilation. We can plug it in as long as it won't blow your papers away. But I can see you struggling, so let's take half an hour now.
I appreciate it, Your Worship.
Till 10:30. 11:30, it's almost 11 o'clock. And then if you would just ask, check the Jerry, you've got the big one. And then you can set it up with the Hikasibota that make it comfortable for you. There are plugs available, and we'll bring it from my chamber. Thank you.
I appreciate Your Lordship. It's a
We'll
good
take
deal.
half an hour adjournment.
All right.
It's just they put
now all of a sudden, it's like, no, we're not in that water. That is the whole line.
I thought they were the way out. They thought it was going to be a quick one. Yeah, they're like, oh, we're sorry. They thought it was going to be a quick one. They're going to read these paragraphs and we have them sorted. And you know, that's why I said I was that there's constitutional authority to say that you can only regulate, you can't rules regulate. Now you're like, oh. I just wish you had gotten a chance to read this because it is exactly, it was a plan, yeah, it was well established that influence behavior.